Yes. So I would like to welcome all of you to this meeting. I would like to thank the presenters who have accepted to be part of this webinar today. I'd like to thank particularly Justice Dingake from the Court of Appeal of Papua New Guinea, Justice Fiona Mwale from Malawi, the High Court of Malawi, and Ms. Sarah Mukasa, who is the Deputy Executive Director of the Open Society Foundation here in East Africa. You are all welcome. I would like to thank also my colleagues who have helped to organize this meeting, particularly Arnold Tsunga and Mukele. Thank you very much, everybody, for your contribution. And to you, dear participants, thank you very much for taking your time and participating in this meeting. Now, on the subject of our meeting today, we are discussing the administration of justice in the context of COVID-19. In line with standard health practice and with the notable exceptions perhaps of Burundi and Rwanda, and Burundi and Tanzania, countries in Africa imposed lockdowns to slow the spread of coronavirus starting around March this year. Various types of emergency laws were invoked to justify this move. In some countries, there were disaster management laws, others, states of emergency laws, and in some, public health laws were used. With the invocation of these laws, Africa experienced what could probably be its most severe restriction of to the freedom of movement. And with the restriction of movement came further restrictions of rights, including the freedom of assembly, the ability to work and to conduct business, a restriction on access to health, education, justice, and a plethora of many other rights as we all experienced them. In the enforcement of these lockdown measures, security forces in various countries tended to use excessive force. Many people were killed, others maimed, and many arrested. In South Africa alone, over 230,000 people are said to have been arrested. In Uganda, I heard the president asking the DPP to release 4,000 people that had been arrested in the process of enforcing those lockdown measures. The courts were limited to hearing urgent matters, bail, and filing new cases. Prisons were overcrowded as inmates that were due to be released could not be released, and yet the prisons were filling with new prisoners who were coming into those facilities as a result of the lockdown implementation or enforcement of the lockdown measures. The vulnerability of women to domestic violence increased. We know teenage pregnancies increased. I think Sarah will tell you that in Uganda they have been counting, I think in some of the sub-counties and districts, counting numbers of young girls, school-going girls who have got pregnant as a result, of being at home. And cases of sexual assaults have also increased. The effect on socioeconomic rights, I think, which Sarah is going to talk to us about, also have been quite severe. And, this has also then brought to the fore and emphasized the inequalities in our societies. The effect on COVID on democracy has also been adverse. You know, in Ethiopia, we have had already elections postponed. In Somalia, they are also planning a postponement. In Uganda, I think there's an argument for postponing, but I think the government and the president are disinterested in a postponement. So there is a debate going on. But finally, there is still no vaccine, yet the numbers are increasing, and there is no telling when the administration of justice will return to normal, which means that going forward, we cannot stop administering justice. The processes must continue, but how do they do so in a safe way that does not endanger citizens? It does not fund the spread of COVID, yet at the same time, access to justice can still be realized by our people. These are some of the things that I hope that this meeting can discuss. And the second part, I really hope that we can raise interventions which can be made in these kinds of circumstances, not just for today, but to address future emergencies. How can access of justice be realized? How can the administration of justice go on in the midst of emergencies? Africa needs to prepare itself for that kind of future. So to start us off, I would like to ask Justice Dingake to have a 5 to 10 minutes discussion on those 3 questions that we had raised when we invited all of you. Thank you very much. The floor is yours. Or is it the cloud is yours, Justice Dingake?
Thank you very much, Martin, and thanks for the very insightful opening remarks you made. 2 points I must make up front. The first one is just to make the little correction that the appropriate description of where I work is the Supreme and National Courts of Papua New Guinea.
Supreme and National Courts
of Papua New Guinea. So we don't use the Appellation Court of Appeal. And 2, to say the obvious that your emphasis was on Africa. Papua New Guinea is somewhere in the South Pacific. And usually there is a confusion. People think I work in Guinea-Bissau. So with those 2 remarks, let me just go directly to some of the questions that you posed. And to say that what COVID-19 has really done to the world is to change, possibly forever, the operating environment that would affect so many sectors. And the administration of justice is not going to be an exception. So it's important that we have this kind of dialogue, because no one can dispute the fact that the administration of justice has been adversely affected, especially the concept of open justice. You know, publicity is the soul of justice, and justice must operate transparently and in the open. Now, with this COVID coming in, this has sort of adversely been impacted. So the measures that the government in Papua New Guinea did was obviously to trigger the operation of the emergency laws as contemplated by the Constitution. So the emergency laws are in operation, and Parliament approved what we call the controller the state of emergency controller, who is the commissioner of police. And the commissioner of police is therefore authorized by law to issue orders in order to minimize the spread of COVID in the country and take all other necessary measures. The result is that the lockdowns were imposed and people were required to work remotely from home. And working remotely from home obviously means that the courts cannot operate optimally. So that has been the challenge. The result is that the judiciary had then to initially we had to ban public access, and only essential or urgent matters were heard, and all non-urgent matters were deferred to some other suitable date. The judiciary in PNG came up with what they called the COVID-19 pandemic plan. So in terms of this plan, essentially public access to the courts were banned, social distancing was imposed, sanitation, masks, and in the past, so what it also meant is that the court staff that were required to come to court, the court had to make arrangements to collect them instead of them using public transport in order to mitigate the spread of the disease. So those were the measures that were taken. And currently we only hear urgent matters. And all other non-urgent matters have been deferred. Yeah, that is that to the heart of the matter.
Thank you very much, Judge. Will I request then Justice Fiona Mwale to speak to us?
Good morning. Essentially, I share in Justice Dingake's concerns that the pandemic has severely curtailed open justice. I think one issue that perhaps I want to highlight from my own perspective is that Justice Dingake has talked about ongoing urgent matters. In our context, we have had several difficulties with what urgent means because it hasn't been defined. So let me start from the beginning. Malawi has actually had quite a good run until March, until, is it April? Until the 2nd of April, we had not registered any cases of COVID-19. And as of today, we have 1,342 cases that are tested positive and only 16 deaths. So relatively, we have not had, the scourge at the level that it's hitting other countries around us. So when the first case was recorded, the president declared a state of national disaster, not a state of emergency. And that had certain implications. Immediately after the state of national disaster, regulations were promulgated restricting public gatherings to less than 100 people. Public schools were closed, travel was restricted, and some measures were put into place. When government was drafting the regulations to include a lockdown, several challenges came up. Now, as you are aware, Malawi was in a very difficult political situation at the time. We've just had our elections, and I think there was a lot of discussion about whether these were to help the pandemic or to frustrate the processes that were going on towards the elections. So immediately after the lockdown was announced, an injunction was taken out, and as we speak, that injunction is still in place. It was taken out on the 17th of April, and so it was granted pending an inter-parties hearing of an application for judicial review on the actual decision of the lockdown. The Chief Justice was then, the Chief Justice was then, an application was made to him to have that declared a constitutional issue so that it would be referred to a constitutional court. So basically what they were arguing was that the lockdown had been met with appropriate social measures. There was no fallback for those who are poor and marginalized. And also that restricting certain freedoms. There were two separate applications for the injunction that were then merged into one. One came from the religious bodies that claimed that it was curbing religious freedom. And another one came from a Human Rights Defense Coalition that had been pushing for a number of issues to do with human rights in the country. So the two were consolidated, and unfortunately I cannot say any more because I am part of the three-person constitutional court that will be deciding on whether the lockdown is unconstitutional or not. But basically, in a nutshell, that is the context from which we're operating. So in response, the judiciary, the Office of the Chief Justice, then issued direction on how matters should be conducted. So the same things that Justice Dingake has talked about, we were to observe social distancing, or no chamber applications, all applications to be heard in open court. Where possible, electronic means to be used, and only emergency or urgent applications were to be heard. Now, unfortunately, because there was no guidance as to what constitutes urgency, different courts are operating differently. And the Malawi Law Society has actually written a letter to the Chief Justice asking if we can have a common approach of the country, an application that has been denied as being agents in the country. Lawyers are the agents of the application before they can be heard. And also different judicial officers are taking approaches. I tend to conduct most of which Justice Dingake pointed out, it has a problem because now nobody can access public trial to, to find out, that which require a lot of exhibits, and there are a lot of people who coming in from prison, and it worries me that if they come into the open and they're exposed to a lot of people, they will then take.
I believe Justice has been disconnected. Justice Fiona Mwale.
Still on?
What are you saying? Mamu,
can you still hear me?
We are having a connection problem. Mamu?
Yes. Justice Fiona?
Yes.
Are you okay now with your internet connection?
Yes, I'm sorry, it's not a very stable connection. I think this time a lot of people are using it, are using the internet. But anyway, I don't know, where did you lose me?
You're speaking about the you worry about prison and COVID associations.
Yes. So yes, as I was saying, a lot of a lot of prisoners are in remand in custody at the moment, and in the first week that COVID case was reported, their cases, when they went back to prison, the other prisoners rioted at the Lilongwe prison. They didn't want them to come back in because they said, you've been out there, you're going to bring us COVID. So there was a little bit of an unrest at the time. We've now had to assure them that social distancing is being observed. So for instance, as I've said, and this is, I can only say this for my court, I will have the prisoners come into court and they will be there with the clerk and no one else. The lawyers perhaps, but members of the public have had to be kept outside, and I will be operating from home. Now, the reason for this, as I said, in criminal trials, you have a lot of exhibits, and these exhibits change hands quite a lot. And in my first trial, after the first case was reported, I noted a lot of things that people were failing to enforce. So for instance, lawyers in property and say, your nose is exposed.
We are having problems.
I remember, you know, because in said cases, you have to have medical personnel giving you, you know, the tendering the autopsy report. The medical personnel who was tendering the report is part of the COVID response team for Lilongwe. And
Mamu, we are having problems with connection.
Yes, I think it's advisable we give Justice Mwale time to stabilize the internet connection.
touching his mask, he kept touching dog, he kept touching his face, and he kept handling the exhibits. So you can see the challenge that a matter which requires exhibits has. You know, the clerk has to get the exhibit from the lawyer, then show it to the witness. Once the witness has identified it, he then gives it back to the clerk, who then has to present it to the court. So each document is being touched at any one time by over 4 people. We would therefore need to come up with ways in which documents can be scanned beforehand, and then maybe we have screens in the courtroom that prevent that kind of touching of documents. That was one challenge that I actually noticed myself. But then there's also the other challenge that now that we're only having urgent applications and not many cases can be heard, a lot of women are complaining that they can't get prevention of domestic violence orders that restrict the perpetrator of domestic violence from gaining access to the house. Some courts treat those as being urgent, some don't. So I think in this scenario, the courts need to be thinking of uniformity. We need to be thinking about court processes to reduce contact, but also we need to start thinking beyond the, you know, when we think right now, the whole world is talking about how domestic violence has increased and, you know, women will need to access justice more. But I think we should also consider the courts that deal with employment issues, because a lot of people are losing jobs at the moment since people have to work from home, and a lot of institutions that mainly employ women, like hotels, have had a lot of women. You know, fortunately, they're being more affected by job losses. Industrial courts or employment courts do to actually make sure that women are being their, you know, rightful benefits in this time. So I think let me stop there and hand over back to Martin. Thank you.
Oh, Judge, thank you very much for that very illuminating discussion on the perspective from Malawi. It has been very interesting to hear what happened in Malawi. It's not very different from what's happening elsewhere, I'm sure. And let's hear from Sarah Mukasa, who is going to tell us a little bit about the socioeconomic obstacles to access to justice in the context of COVID. Sarah. Sarah, we can't hear you. Mamu, we can't hear Sarah. Can you do something about it?
Hello, can you hear me now?
Yes.
Okay, let me try it this way. Thank you for inviting me to be part of this conversation. I'm not a legal practitioner, and so Martin very kindly asked me to just speak about some of the socioeconomic you know, sort of impacts that may affect access to justice on the continent, and not worry about the legalese in terms of framing. So, it's great that much of what I'm going to say has already been said. But what I'm going to try and do is I'm going to try and outline a number of sort of economic factors on the continent that, to my mind, have an impact on access to justice before the law, but perhaps more importantly on justice, which we understand as the enjoyment of rights and freedoms by virtue of our humanity, and that these principles are underscored in most of our sort of constitutional and legal provisions. Now, on the sort of economic front, COVID-19, I think sort of unearthed many of the structural economic inequalities between people and between nations. Whereas Africa, many parts of Africa have been recording record growth in the Africa Rising narrative, we are seeing a growth which has, by and large, no connection whatsoever to our social welfare priorities and provision. We are registering record GDP growth. At the same time, we're unable to produce jobs. We're unable to meet our health needs, our social protection needs, and so on. And what COVID-19 has exacerbated is the sort of breakdown of global supply chains, which will result, for example, in Africa being at the bottom of the vaccine access chain, while rich nations are negotiating preferential access. So even the vaccine, when it comes, our access to that vaccine is not assured. We will be on a sort of waiting list once the wealthy nations of this world have negotiated their access priorities. And we saw this very clearly in the sort of global scramble for medical equipment, such as ventilators, PPEs, and so on, where we in Africa were simply outbid by countries such as the US. The impact on food, our food import bill as Africa currently stands at around 37 billion per year. Now, with COVID-19 and the breakdown of these global supply chains, what we're going to see is that this food import bill is going to increase significantly as countries around the world stockpile their own as they stockpile their own food in the wake of the pandemic. And as somebody has said, we don't know how long this pandemic is going to be with us. We don't know when we're going to get a solution for it. We don't know when the epicenter of COVID-19, or we don't know when when we are going to hit our sort of epicenter on this continent. And so the cost to us for importing food is going to be disproportionately high as other countries stockpile their food, as the cost of transport and so on increase. And what we see is that most countries on the continent are ill prepared for this. For example, in 2018, a country like Uganda had a standard storage capacity of only 920,000 metric tons of maize grain, and at the same time had a bumper harvest of about 4.6 million tons. Now, instead of preserving that bumper crop, what it did, it sold it off because it didn't have the capacity to save. Now, the lack of this preparedness will increase the crisis in food security. And I think creates significant challenges in terms of access to justice so far as socioeconomic rights before the law will be presented. We, on top of that, are facing a crisis currently where 250 million people on this continent are malnourished. And under COVID-19, this is likely to increase. In addition, 9 out of the 10 most climate vulnerable states in the world are in Africa, where at the same time their populations are increasing. We will see increasing drought and floods. We're already seeing a locust crisis in the eastern horn of the region. The significant threats to biodiversity will increase, and exacerbate the need for access to justice along socioeconomic rights. On top of all this, we have highly indebted countries without the fiscal space to provide adequate social services. Even though we have seen that many countries on the continent have significantly increased their expenditure on military and internal security. Many governments addressed COVID-19 initially as a security issue. So against this backdrop, we have seen that COVID-19 in most African governments has been dealt with by a series of sort of executive orders, state of emergency and declarations and so on. We have seen a practice of lockdown, which in many people's views, essentially criminalized poverty and impoverishment. As many of you have said, the lockdown measures were implemented against highly inadequate measures for mitigating the livelihoods insecurity, and the sort of fallout from that is we have seen, as some of you have said, the imprisonment, the arrest, imprisonment of many of the people who were within the context of the lockdown trying to address critical livelihood and basic survival needs. In countries like Uganda, and I think really all over the continent, we have seen pictures and news stories and so on of many people, especially women, who have been languishing in prisons for sort of violating curfews, and their crime is that they were selling tomatoes or oranges or something to provide for their families. Not only have they been imprisoned in conditions that probably exacerbate their exposure to COVID-19, but many of them have left families. We are dealing with cases where women left in the morning, left children at home, and have not been seen for the past 3 or 4 months. And so we're, trying to address those kinds of fallout. Again, we're seeing an increase in violence by both state and non-state actors. As has already been mentioned, the violence, domestic violence cases against women, but also by state operatives who have been enforcing lockdown. And in a number of countries, many people have been killed from the excessive force used in enforcing lockdown than have died from the virus, for example. We've seen an increase in maternal deaths, penalizing those who are seeking medical assistance in the sort of lockdown and curfew periods. In Uganda alone, the country was dealing with an increase in maternal deaths, of reported maternal deaths, of about 3% of the national average at that time. And this is just during the lockdown period. Now, the increase in domestic violence has led to a number of women's rights activists in countries like Nigeria and Sierra Leone calling for a state of emergency around addressing gender-based violence, rape, and so on. In a country like Kenya, national figures for girls between the ages of 10 to 14 registering pregnancies between the months of March and May were 10,000. And these are girls reporting to medical services. So that does not in any way reflect the national average. Of course, the issues around the protection of workers' rights. We have seen unscrupulous practices in sort of layoffs and failure or refusal to pay what is owed, or the imposition of intolerable working conditions for those who are desperate for work. Now, in our view, these kind of place what we would think are, and sort of compound the already considerable challenges in terms of access to law, access to justice before the law. And there have been several arguments put in on, I mean, these are not new to you as law practitioners. Of course, the delays that many of you have talked about. But I think, for many of us, we think that there will need to be some fundamental shift in our understanding and exercising of justice. Already, we see that the vast majority of people on the continent do not access justice for a number of reasons. The cost, the language used in courts of law, which many do not have access to, the orientation of the practitioners and law enforcement and judicial systems, the training received in formative years as lawyers, and so on and so forth, create what we think is a huge disconnect between the society and the the space that is the process of justice to which all citizens are entitled to. We feel that COVID-19 presents an opportunity to really rethink how we administer access to justice in the context that we're operating in. And therefore, I sort of look forward to more discussion and more elaboration on amongst you on some of these issues. Thank you, Martin.
And thank you very much, Sarah. It's been quite a mouthful, you have said, and there are already questions arising from what you have said, the questions arising from what Justice Fiona Mwale said and what Justice Dingake said, which I'll read out later. But I also want to say to Mamu, if we can figure out a method for participants to ask orally these questions, that would be a better approach. Otherwise, I will read them out. So let's go to Mr. Franck Kamunga, who is a legal expert from the DRC and currently based there. He has worked before in South Africa with your colleagues, Sarah, the Osisa. So he was with the Open Society in Osisa in Southern Africa for quite a while. So Franck, you are very much welcome. We have communicated before by email, but this is the first time we are going to have or at least an image of each other. You're welcome, please go on. Franck, the floor is yours. Franck? Mamu, can you facilitate Franck, please? Mamu, can you kindly facilitate?
Yes, I have.
Okay, thank you. Thank you very much, Mamu. Monsieur Kamunga, bienvenue. Monsieur Kamunga, il y a problème?
I believe he's having the same issues Justice Fiona was having earlier on with the internet connection.
Okay. So as you connect him, can I? Okay.
Hello. Can you hear me now, please?
Yes, we can.
Yeah, thank you so much, the colleagues and panelists and the organizers of this important meeting. I really appreciate that we've got this opportunity to discuss about this issue about justice administration during this COVID-19 time, which appears to be challenging for most of our countries and most of our regions. I will just a bit of information about what is actually happening in the DRC, and probably from the questions and conversation we have with the other parties as well as the participant, we can provide more details and so on. First of all, I want to just emphasize the fact that the independence of the justice is actually provided within a constitutional provision, which is the Article 150 of the 2006 Constitution of the DRC, which is the independence of the justice from any other powers or political impact in the country and political powers and so on. For the last 3 months, we have experienced a lot of issues that I'll be happy to share. Hello.
Hello, go on.
Oh, okay, thank you. So,
the line is so bad. Mamu, the line is so bad.
Yes, I really think he's struggling with this internet connection there.
And I have this suggestion, Mamu. Let us have the questions that have been put to justice, to the judges and to Sarah. Let them answer these questions as we give the issue of Kamunga's connection time to sort itself out. Is that fine?
That's fine, sure, no problem.
Okay, so the first question is from Justice Mavedzenge. He's putting this question to Justice Mwale and Justice Dingake. He's saying, what kind of factors do their lordships think should be taken into account in determining whether or not a matter is urgent under COVID-19? I think the way the question is framed, it's to both of you. So I I guess that both of you will do a bit of an answer.
Okay. Should I go first, Martin?
Please, first have the first bite on the cherry.
Yes. If I recall, this justice fellow who is asking the question is a lawyer. And my answer to him is that judges don't give legal advice to counsels. But having said that, in terms of it's a point, a very valid point that my sister Mwale actually raised as to exactly what constitutes agency, and it's disconcerting that in one jurisdiction you may have different approaches as to what amounts to agency. So those approaches tend to yield different consequences for litigants, even in situations where the facts and circumstances are materially similar, where Justice Mwale may determine differently to Justice Dingake. So she's spot on in saying that we need some uniformity on what actually amounts to agency. I often say to lawyers when they come before me on any matter alleging agency, I would say, well, if you demonstrate that the sky is falling, then the matter is urgent. And if it is not falling, then there is no agency. But in the context of COVID and digging deep in our own jurisprudence in Papua New Guinea, I think what appears to be fairly established is that issues affecting personal liberty, personal safety, and health would, in my mind, qualify as agent. Remembering, of course, always that agency is relative, and there are various degrees of agency. But otherwise, as a general rule, matters affecting liberty, personal safety, and health would be agent. I'll also add another category. Time critical proceedings that are time sensitive may well be regarded as agency. So those are some of the factors that I would regard as agent, bearing in mind, of course, always that it is the circumstances of each case that may define agency. Prejudice on its own per se that may be remedied in future may not necessarily amount to agency, or any injury that is not necessarily irreparable may not amount to agency. So that would be my take on that. But I underscore the very valid point raised by my sister Fiona that we do need some uniformity if we are to be more effective in the dispensation of justice. Thank you, Martin.
We shall go to Justice Mwale.
So much. I really don't have
Okay.
my learned getting an injunction of agency where you justify what as that Justice Dingake put it, that the sky is going to. So I also just lawyers.
Justice Mwale seems to be having the same problem as Mr. Kamunga.
I'm going to switch to my phone. So for now, I agree with Justice Dingake.
Hello? I didn't hear. So, Justice Mwale, are you done? Are you finished?
A better network. Now
or network problems. Okay, so let's ask let's ask Sarah to answer her question. We hope that your problem will be sorted out by the time Sarah is done. So the question to Sarah is from Jean-Claude Varakamufitiye. And he is saying, hello, thank you, Sarah, for raising the important point that African countries can be at the bottom level when access to vaccine against COVID-19 is concerned. Don't you think that it is time for African countries to use the compulsory licensing to produce vaccines locally when they are released?
Yes, the short answer to that is yes. It's important in the COVID-19 period, the Africa CDC, Center for Disease Control, has done a great deal to raise those questions in terms of what the legal and policy framework is to enable the development of local supply chains in medicine and also in the necessary equipment. There are certain trade, I mean, these are complex legal sort of minefields around trade laws and so on that need some, I would call, legal advocacy to try to address intellectual property rights and so on, that need, there's a quagmire that needs to be sort of walked through before that principle can be fully established. But there are precedences. I mean, you know, HIV, ARVs and so on were challenged on that very same principle around access and costs and around, you know, developing local capacities. My suggestion is that now is the time for, you know, those in the legal profession who are interested in these matters to put their minds towards them in order to lay a clear framework in which that principle can be established and happen on the continent. So yes, I firmly agree with that.
Yeah, thank you very much, Sarah. But well, we can deal with how to work with medicines and drugs and diagnostics that other people have used, and then still end up in difficulties. Isn't the more profound way, the more fundamental way of dealing with that problem to simply start a process of innovation? Africa is not innovating these drugs. We are talking about buying the drugs of other people and then trying to go around the minefield of using those drugs. What if Africa began thinking itself of investing? Because the problem is that we are not investing in the scientific and technological innovation. Okay, we have seen that this time there's probably been an attempt. The Africa Development Bank has recorded 192 innovations, you know, well, over 200 innovations now from South Africa, Kenya, Uganda, Senegal, and Ghana and Nigeria, around alone. And some of these actually involve the attempts to make
It's 11 hours.
the vaccines. Sarah will know that both Kenya and Uganda have privately invested for the first time in in innovating vaccines. You know, so isn't that probably the fundamental way of solving this kind of problem, rather than looking at how to, you know, go around the legal minefields of drugs used by others? Because we always go into these problems when you have an emergency. This.
I think there are some immediate sort of short-term and overall long-term things that need to be done. You know, the need for investment and innovation, and like I've said, the African CDC, the African Development Bank, and so on, a number of different countries have seen the light and have, you know, tried in a to put that infrastructure in place. The truth is, though, that that infrastructure will take time. I really, you know, in the long term, the innovation, the investment in research and development, the capacity and the infrastructure on the ground to be able to produce our own sort of medicines, vaccines, equipment, all that is there. But I think there is also an immediate issue. It doesn't remove the sort of immediate issue around the need for access to those drugs that are being, you know, developed, you know, in the sort of, I guess, the sort of traditional hubs where these things are done in the north. There still is a very sort of immediate need. So I agree with both points. You know, saying that if we do have a coherent plan that addresses what our short-term as well as invest in our long-term needs around self-reliance and self-sufficiency in medicines as well as equipment that we need. Yeah, those are both valid.
Okay, thank you. So there are some questions from Makanata, Makonese, Washington, Katema, but I would prefer maybe that if Franck is back online, that we hear him before these questions can be answered. Franck, are you back on air?
Yes. I think that I hope the line is better now.
Okay, yeah, it is. Bienvenue.
Yes, thank you so much. Thank you so much, Martin Okumu. Thanks to the organizers as well for giving us this opportunity in quite a difficult time. And talking about justice administration this time is such an important issue for us because of the way our regions and countries are affected all over the world. And I'll give a little bit of information on the DRC, probably from questions and conversation with other panelists, we can give more details. But from now, what I can say is that, first of all, within the DRC Constitution of 2006, there is a provision at Article 150 that guarantees the independence of the justice from all impact or all political powers from the legislative and the executive powers in the country. But for the last 3 months, we've experienced huge challenges in terms of justice administration. And I hope some of you have heard about the passing away of Judge Yanyi just a month ago, was actually dealing with a huge case of corruption among the president office, especially the chief of the president office, Vital Kamerhe, which actually explains the difficult time that the justice administration process is going through. And I'll also talk a little bit about the access to justice challenge, which is actually one of the most important issues in the country, because we've got a lot of people in prisons waiting for trials, but because of the reduction of the minimum service, because the country is under the state of emergency since the 19th of March. So that means there is reduction of services, the minimum services that is actually allocated and allowed, not only from the public services, but as well as for the justice systems, which means very minimum judges can go to court, which also means that very minimum people waiting for trials can have access to justice. Apart from that, there is also three bills that are underway to the parliament, proposed by the former president Elias. You've got the majority in the parliament still under control of the former president Joseph Kabila. And to make sure that escape from the judiciary, as you may know, there has been a lot of cases of corruption for the last 18 years, and the change at the head of the state has moved the justice administration to another direction, because for the current president of the DRC, the justice is actually the leitmotif of his mandate. And they really want to maintain the justice independence to ensure that there is access to justice for everyone, and also that the fact of being a leader in a political party does not prohibit someone to be persecuted for anything that is done in the past. And the main cases actually underway are the cases around corruption. The first person to be persecuted is his own chief of cabinet, which is showing the impact that could have on the rest of the political leaders. So the former President Kabila with his party and alliance, they have actually prepared 3 bills and submitted to the parliament for review. There has been a huge riot and contestation from civil society, from the current coalition alliance, UDPS, and also from the judges coalitions, for 3 reasons. The first one is that these bills are putting the judges under the authority of the Ministry of Justice, actually giving him the authority of making disciplinary measures on judges, actually giving him the authority to preside the judges' high council, which the magistrate high council, which is actually the high core that leads and actually provides support and advice to the judiciary in the country. So I wouldn't imagine that a Ministry of Justice, who may not be a lawyer, who may not be a magistrate, who may just be appointed by a political elite, should be the one leading that National Council of Magistrates. So there's just too much power taken from the Council of Magistrates and from the President party. These bills are even giving the appointment authority to the Ministry of Justice for some magistrates. So which is actually really undermining the authority, the independence of the justice. So that has been a very, very huge fight, actually, which is underway. The bills have been submitted in the parliament and revoked for the other opposition MPs in the parliament and civil society. But they're pushing as much as they can since they have the majority in the parliament. But we just believe that things may turn out otherwise. But they're really pushing for it, and they want to have full control of the judiciary. The second point I also want to actually elaborate is the fact that the state of emergency, I would say, as you all know, that justice delayed is justice denied. There are people that have not been tried for, serious months waiting for trial. And now, because of the COVID-19, they can't access justice because the national judges are actually out of service. So how do you put these together to maintain and keep access to justice going on? At the same time, pay attention to the provisions that need to be put in place to avoid people from getting sick or getting infected by the COVID-19. So these, I think, are some of the important questions that we have to take forward. And the third point I really want to also to elaborate with the panelists is on the access to justice and freedom of expression for human rights defenders and pro-democracy activists. As you all know, it is always a problem for human rights defenders in most of the countries that take the forefront to maintain fundamental rights at any time, including within the COVID-19 period, despite all the measures that are taken to maintain the people safe. But there are fundamental rights that need to be respected. There is abuse, excessive use of force actually to persecute those who are not complying with the measures. There's a huge restriction on freedom of expression, even within the media, because you have to make sure that the information you are providing as a media has to be conform to what the government or the Ministry of Health is publicizing or providing to the public. And that is also putting too much pressure and too much persecution on journalists and human rights defenders that want to maintain respect for human rights within the COVID-19 frame. So I think all these are really important and quite urgent issues that are really need to be discussed and forward. There is a letter that we really appreciate that has been circulated by SALC, expressing solidarity and pushing for the independence of justice. That letter is to be sent to the Special Rapporteur on independence of justice, which actually clearly explained that despite the fact of having COVID-19 within the country, the independence of justice should be maintained. And the passing away of Judge Yanyi, who was actually killed and assassinated because of his pressure and the case that was taken forward on the chief cabinet of the president of the DRC for having taken over or supported the disappearance of over $14 million dedicated to prefabricated hours and so on. So I really believe we need to rethink how should our work move forward within that framework and how kind of support should be provided both to judges to maintain the independence despite the pressure that they are going through, as well as the lawyers community, because they are part of the work around the justice administration that actually are also being put on pressure because of the COVID-19 round, and they can't access to the client in prison. And I'll actually support what I think Judge Fiona was saying before around the prisons, you know, and the Kinshasa actually, we having over 7,000 cases of COVID-19, and in the prisons we do have cases. But what is being done to keep people safe in the prisons, but at the same time allow them to have access to justice and allow lawyers to actually have access to the systems and to the client and keep the justice running? So I think these are quite important conversations that have not taken place, and I really appreciate the fact that some of the colleagues have taken very strong courage to start these conversations around the continent. These are things that are not happening, and I really believe this is going to take long. The cases are growing up, things are going up. I'm not convinced that COVID-19 will stop very soon. So do we stop making sure that the justice administration is functioning properly until the COVID-19 is over? That's not something we can allow. So how do we move forward? Keeping people accessing justice, keeping people in prisons, take advantage of accessing the lawyers, accessing justice, and making sure that they are treated properly and have access to justice in whatever condition it is. So there should be a way of getting that organized. There should be a way of providing people space for conversations such like this, as well as providing space in countries on the region to maintain the justice independence, maintain the work of lawyers in the countries, and to maintain access justice for all those in need. So I really want to appreciate the contribution from all the panelists, and I really believe that we'll have access, we'll have support from all the region to put away these bills that are actually put in the DRC parliament to control the judiciary and to maintain the political power on top of the judiciary and control, every single process against the political leaders that want to make sure that no case of corruption is followed. And I'll just end by that. It's very funny that the Ministry of Justice of the DRC received these bills. It's an organic law conforming to the justice legal system. This draft bill have to go through the government, to the Council of Ministers, discussed, and then provide with input before coming back to the parliament. But unfortunately, the Justice Minister received these bills. He organized his own commission within the Ministry of Justice and sent back these comments as the government comment to the parliament, because they belong to the same political party with the president of the parliament. Surprisingly, when the Prime Minister was aware of that, he actually, and the president was aware of that, he actually instructed the general prosecutor to follow up the case. And he was arrested actually for a couple of days. For 1 day and then released later on. But the case is going on because it is the Ministry of Justice who is supporting these bills, because these bills come from his own political party. And he wants to have the power to control the justice and make sure that his people who have been incorporated in a lot of cases of corruption are not persecuted. A lot of substantive human rights abuse are not persecuted, because this is how they think it should be. But I really believe from this important conversation, from this contribution from different judges and the Judges Forum that I really support, we can maintain a certain standard of justice within the region and keep our solidarity strong enough to make things move forward and make sure that people have justice and access to justice despite the COVID-19. Thank you so much.
Thank you very much, Mr. Kamunga. Mr. Kamunga's presentation reminds us of the pre-existing situation environment within which our judiciaries and justice systems operate. So while COVID-19 is a big problem, it probably only exacerbates situations that have already existed, like this whole question of the lack of independence and the struggle to strengthen and maintain an independent judiciary. But he also tackles the other issue of alertness of judges to the instrumentalization or weaponization of the judiciary against people that speak out or speak for human rights. And I think that's a very important question. It's what some people call judicial persecution. How alert are judges to the judicial persecution of human rights defenders? Again, it reminds me of another issue that Sarah had raised on access to justice. And she was raising these very odd questions, which other than outside South Africa, I think very few judiciaries seem to be alert to, very few countries are trying to address. The question of the court architecture, for instance, and how that intimidates both lawyers and litigants. You know, the language used in courts, how it just excludes the litigants from their own processes. You know, the use of this court regalia by judges, the wigs, even when we know that the judges themselves are so uncomfortable in them because they're not meant for this environment. the attitude even of some of the judges. You know, one judge told me one time that you see that when everybody is calling you Lord, Lord, at some point you begin thinking and feeling as though you are the Lord himself. You see, of course, it's a funny way of putting the problem. But you see, it's something that gets into the orientation of the judge. And for those lawyers who have gone in and out of courts quite frequently, they will tell you how rude a good many of the judges can be, you know, and that too undermines access to justice. So these are a number of things that are pre-existing, you see, in the way the court system has been run, which have only been exacerbated by COVID-19. Justice, I guess, is a judge. Charles Hungu, I think, is the judge in Zimbabwe. He's asking, don't you think that this is time now to digitize the courts? Ndaikunda, I think Ndaikunda must be from Burundi or Rwanda, is simply saying he feels honored to be here, to participate in this meeting. There is an organization called International Bridges to Justice. I think Arnold and I met them in Switzerland. They have also written saying that they are pleased to be a part of this conversation, and they have shared a link there to the work they have done for a checklist for lawyers on COVID-19 and lawyering. And yeah, so those are, then we have a comment from Sanjewa Liyanage to all panelists. Thank you, Frank, for highlighting the importance of access to justice and the role of lawyers. Arnold, can you please send me an email to Siyanage? Okay, for the toolkit, okay. Yeah, so those are some of the issues that have been raised so far. Maybe you could answer those before I put to you two other questions, one from Makanatse and another from Washington. The question of access to justice, on all these things, the wigs, the attitudes, the court architecture, you know, the language, you know, the environment of the court and how it intimidates and makes it an access to justice issue and makes it difficult for litigants and sometimes for lawyers as well. And then the question of alertness, you know, to the weaponization of the judiciary against the human rights defenders, and the question of judicial independence, pre and during and post-COVID.
Well, thank you, Martin. That's quite a mouthful, eh? And I noticed that you allow yourself to be in contempt in suggesting that constant referral to us as laws, we end up believing that we are laws. You can say that from the safety of Kampala, where you are. Otherwise, you'll be in trouble. But you see, let's just say this: COVID has exacerbated. I like the point you made, Martin. Existing problems around the administration of justice in Africa. And it would be erroneous to pile everything and blame everything on COVID. What it has done was to exacerbate issues that some of them you highlighted. Way back 3, 4, 5 years ago, before COVID came into play, when I was traversing Africa under the Africa Judges Forum with Martin and Arnold and other colleagues, we came to learn that in many countries, there are still people in prison awaiting trial for years, for many years. I don't want to name the countries, but across Africa, it's quite common that there are many people who are spending years awaiting trial. Some have even almost concluded what would have been the maximum sentence when they convicted of that particular offense. So, so those are serious issues, serious indictment on the administration of justice in Africa that have been exacerbated by COVID. Because what COVID has now done is to make things worse. The primary concern is about the safety of judges, court staff, litigants, and so forth. And the courts are not operating at the optimal. And as Frank rightly mentioned, justice delayed is justice denied, and justice is sweet when it's fresh. I can give you an example about yesterday, 1 or 2 days ago in Papua New Guinea. One of the lawyers tested positive. So the COVID came right into the courts, and as a result of that, the court's operation have almost been suspended now, as other measures are trying to be done to secure the safety of judges, litigants, and court staff. It has been quite disruptive, but we should, in the course of time, as jurists, as lawyers, as all stakeholders, converge again to say, how can we transform the administration of justice in Africa and ensure the independence of the judiciary across Africa, and make sure that the judges are truly independent. And this one question, the independence of judges cuts across so many selection methods, the overbearing powers of politicians on the judiciary and so forth. Those are matters that we should discuss. Earlier, Martin, you talked about the state of emergency. Many countries have adopted the state of emergency in order to address COVID. In some situations, declarations of state of emergency were not necessary at all. They were invoked in order to limit rights, sometimes unnecessarily, including issues of expression, freedom of expression, because the ruling elites did not want to be critiqued, even on the way in which they are approaching COVID. So that is wrong. But what is important for us talking about the administration of justice is that the administration of justice is an essential service. And COVID cannot stop the wheels of justice from grinding, because at the heart of the administration of justice is the imperative to observe the rule of law and to protect rights of citizens and within the parameters of the law. And in PNG, and in terms of the jurisprudence that is there, the right to life under the Constitution cannot be compromised under any circumstances. And there are some other rights, and there are others where the freedom of movement and others can be limited. But if there is any limitation on any right, it should be because such limitation is reasonably justifiable in a democratic society, or as other constitutions say, the limitation is necessary. So there are all these challenges that we need to attend. I'm only hoping that this conversation will cement this union, these linkages that we are building, and to ensure that we lay out a clear program, systematic program going forward about ensuring that quality justice reaches our people. What many courts are now doing during the course of COVID is to use technological platforms to hear cases, MS Teams, Zoom, just like we are doing. But these technological platforms have limitations, as you know. We just struggled to hear Frank. It took some time for Frank to come through. So these technological platforms that we are using, they have challenges. And what about unrepresented poor litigants who may have urgent matters to be attended? They don't have access to these technological platforms. That is not to say that we should remain in the Stone Age. No, The courts must move with the times. We must use technological advancement in order to advance the cause of justice. But we must be careful that we don't leave the poor out of the picture. And by the way, it is the poor who need justice more than the rich. And we need to bear that in mind at all times. Thank you, Martin.
Thank you very much for that elaborate response. Justice Mwale, do you have?
Yes, I just have a few words to add. I totally agree with what Justice Dingake has said. In terms of making the courts more accessible, I think everybody has rightly pointed out that COVID is merely exacerbating existing challenges. Now, I am speaking as a judicial trainer. I am a member of the International Association of Women Judges chapter in Malawi as the national training coordinator. So I do a lot of trainings on gender sensitive adjudication, since women tend to fail to access justice due to, you know, structural barriers, poverty, and things like that. And since now that we have COVID, it's exacerbating the situation, women will even access justice less. And so, you know, I, on behalf of the International Association of Women Judges chapter, have devised a number of gender-sensitive adjudication curriculum that are even more important in the COVID context. So I think it's a time to start retraining judges on how to make themselves more accessible. If a courtroom is not physically or structurally or inaccessible in a number of ways, what can we do lawfully to make ourselves more accessible? In children's cases, you know, by law, we can take off the wigs and gowns. What can we do to make women more comfortable? That's an issue that we're exploring right now in Malawi, and I think that we would all do well to consider those issues. But again, also as we're talking about COVID exacerbating existing conditions, you know, we have said that applications involving liberties or hearings involving loss of liberty are very important and must be treated as urgent. In my court, my practice has been that I'm hearing bail cases on the papers. So I don't see anybody. I will just receive the affidavits, or as we're now calling them in Malawi, sworn statements. I will receive sworn statements from both sides with any exhibits, all on the papers. And what I'm finding is that, you know, you don't have the lawyer in front of you, so you can't ask a number of questions. For instance, you want to set a bail condition on, you know, a cash bond. The issue is, how much money can this person afford to pay? You don't want to set a bail bond that's too high. And the lawyers have not put that in their affidavits. So what is showing here is that, you know, that basic concept of lawyering, making sure that your affidavit has everything that in the past we have tolerated because they were there in front of us and we could ask them questions. Now it's exacerbated. I don't have the lawyer in front of me. And if they don't have all the details, so now more than ever, lawyers should be very, very precise and meticulous and pay attention to detail, because in many cases, they will not have immediate rights of audience. So I think as we are moving forward, COVID is going to be around for a long time. Yes, indeed, we are exploring digital access, but even in digital access, as we have seen, you keep losing people. You will rely on the papers a lot more. So I just wanted to add that you know, women's issues will be exacerbated. How can judiciaries respond for access to justice to women? And also, how can we encourage lawyers to be more precise than they have been? Thank you.
Thank you very much, Judge. We're going to have Kamunga. Did you raise your hand up?
Yes, please.
Please go on.
Yeah, thank you so much, Martin. I just want to have a very short comment on two issues. First, I would like to emphasize the solidarity among the judges community. And I think I've raised this with Arnold before, that the language barriers between the regions is somehow affecting this process and does not contribute much to elaborate and include some additional regions because of the languages. I'll raise the case of Judge Bui, who was killed a couple of years ago in Lubumbashi for having intervened in a political case among political leaders. And I've raised a couple of minutes ago the case of Judge Yang, who was killed after 2 hearings against the chief cabinet of the president of the DRC. And they look, I mean, it's like they don't feel really the regional solidarity that is required. And I really believe it is important that we take this point forward and find a way of, if judges, I mean, Francophone judges and Lusophone judges can feel the solidarity of the region within the forum, what is the best way to go forward? Because solidarity is so important to ensure security and independence of judges, because some important decisions can only be taken when they feel comfortable and when they feel there is a community behind them that could support their independence and the courageous decisions they take on some important issues on corruption or some grave and massive human rights abuse or whatever it is. But there really is a need for us to rethink of how do we incorporate the Lusophone and Francophone region between the forum to make sure that it is really that solidarity. The very last point I want to raise is around the, I think one of the panelists has pointed it before, is about the access to justice for victims of, I mean, violence against women or gender-based violence, what I'd say. There is a huge rising in most of the countries on women, which I will call really huge violence against women. And for these cases, because of the COVID-19, there is a big challenge on providing them the space to make sure that they have access to, or they have some kind of protection from the judiciary. So these are some of the points I really want us to take forward and rethink what may be the process. So the case of the solidarity among the judges out of the English-speaking countries. So I'm looking at Lusophone and Francophone countries, and then the issue around gender-based violence and maybe the violence against women in most of the countries, specifically to on accessing justice. Thank you.
Okay, I'm going to say something a bit about the solidarity of judges. You just took it out of my mouth. This is an issue that I had a discussion with just last night. A discussion I had on just last night with the chairperson of the chairman of AJJF, because we have drawn a list, but the question of our members and their contracts, and the question was, how do we integrate them with the Francophone judges, because we do not speak the same language. So this is an issue that just Dingake, myself, and Arnold are going to have a discussion on later and see what we can do about that, because there is a real challenge there, you see. Then on the question of violence against women, well, I'll leave it to the other panelists to respond, maybe at some later point. For now, I would like to read out a few questions. One question, okay, Fiona, you will, I mean, not Fiona, Sarah, you will speak. I just want to go through these questions. A question from Makanata Makonese is to the justices: have the judiciaries in your countries considered using technology to completely avoid movement of prisoners during the pandemic? For example, setting up video links between the prisons and the courts. Okay, two is from Washington, Katema. To what extent has the Honorable Justice's jurisdictions relied on these technologies such as Zoom to administer justice during this pandemic era? I know Kenya has tried to use this model. Is it working, or it brings a lot of admin issues? Okay, but I think this question has generally been responded to. But if Justice Mwale wants to say something, or Justice Dingake, please feel free. or if Sarah wants to share the experience in Uganda. In Uganda, there's a link between the courts, a video link between the courts and the prisons. So your bail application, you don't have to come to court to get your bail application heard. So your bail application can be heard while you are in prison, and there will be a video link. You have a link, you have a screen, and the judge has a screen. Unfortunately, it's something that was being, I think, rolled out throughout the country at the same time when COVID struck. So currently it's operating only within Kampala and the environs of Kampala.
Martin, there's
Yes.
Professor Ansungule wanted to have a question. Maybe if people are going to answer, it might be a good idea to give him, because he's been promoted to a panelist and he can be able to speak.
Oh,
so that the questions can be asked. Yeah, he's on the platform.
Okay, so Professor Ansungule, go on with your question or comment. Professor Ansungule, please.
He's muted currently. His mic is muted.
Can Mamu help? Mamu, can you help unmute Professor?
Yes, we're on it. We're on it right now.
Okay, as you're on it, I'll read a comment from Mary Da Silva from Swaziland. She says, she says, in Swaziland, courts are operating in an attempt to allow for access to justice, but the restrictions imposed by the regulations make it difficult for people to attend court. Restrictions on travel, lack of finances for transport or legal representation due to limited economic activity. Women face the brunt of it because they are normally the most vulnerable, and the regulations have made things worse. They are forced to stay at home. Despite that, it's not a safe space for them. They have no access to sexual reproductive health services, are unable to use normal they are unable to use normal reporting channels and continue to face stigma. In cases where people are able to access the courts, they face the added risk being infected. So that's just a comment. Sarah, could you go on with the response you wanted to make? And then we shall hear Michelle. He has come on screen. Sarah, please.
Yes, thank you. I was just adding to the sort of questions around what COVID-19 is exposing in terms of already pre-existing conditions or pre-existing challenges. And I want to say two things, I think. I think what we see with COVID-19 and its impact on the continent, infection rates still remain, even though they're going up, they remain quite low. So the largest impact has been one of a socio-economic sort of nature. The livelihoods, the disparities between people, we have talked about women, but you know, there are all kinds of disparities going on on the continent against people based on age, based even on sexual orientation, and so on. Which impacts their ability to access justice. Now, digitalization, of course, takes care of some of those impacts, but I think the larger question for us is the questions around the sort of inherent bias of the legal system and the sort of plethora of laws that exist that in a sense, together with the COVID-19 lockdown measures, what I said essentially criminalized poverty and the impoverished. So I wanted to ask the legal practitioners here. For example, there are a whole lot of laws, what we call under sort of an auspice of the petty laws, what we call petty laws, loitering with intent, you know, those kinds of laws which are used against people who, you know, socially excluded people, poor people, are used against them to harass them and to imprison them, resulting in huge backlogs of people in prison awaiting a hearing. You know, there have been various...
Excuse me, sir.
Yeah.
Can I interrupt? So that you do not have to go and come and leave and come back to the floor. I'm told that Michelle would like to ask a question, to put a question to you, so that as you make that comment, you also respond to Michelle. Professor Michelle Hansungule, can you please proceed with your question? Professor?
Good morning, Martin.
Good morning, Professor Hansungule.
You get me now, thank you. And
yes.
Thank you very much for inviting me. But also, I wanted to greet my colleagues, Judges Dingake and Mwale, and all the panelists. It's a pleasure to join you, to be part of this important process. What I wanted to ask, first of all, is do we know, for instance, how many judges, African judges, or judges in Africa have been affected and infected by coronavirus? Is there any study, for instance, by ICJ Africa Office and other non-government organizations in terms of the welfare of the judges in Africa? Whenever we speak about this disease, it's almost like it does not affect us. I think it's time we also turn to ourselves and see the extent to which some of our people that we are talking about now may be affected. What measures are being taken in the various jurisdictions to try and conduct and carry out tests among judges, among magistrates, and what kind of a picture do we have of their welfare since the outbreak of this disease? Similarly, one would also like to say, what about lawyers, African lawyers? Do we know the extent of the pandemic in this particular group of people responsible for the administration of rule of law? Have we not done any studies, any researches to determine the extent to which lawyers may have been affected directly? And then related to this is the issue that you have raised in the discussion already, the issue of judging in Africa. I think that if you look at some of the cases so far, some of them you have highlighted them in Malawi, you have highlighted them, some of them in South Africa. The rulings in relation to fundamental rights and freedoms, the effect of coronavirus or COVID-19 on fundamental rights and freedoms in Africa. How have our judges responded through the various judgments? The robustness of our judicial systems in Africa in trying to protect, to decide cases, of course, based on law, but to ensure that fundamental rights are upheld. As you know, many countries, as the judge from Malawi, Justice Mwale, has mentioned, have tried to avoid invoking preservation of public security regulations deliberately. So they have invoked ordinary pieces of legislations rather than public security legislations, obviously because of the likely conflicts that these legislations would have. And so they are not accountable, for instance, to international bodies like the UN Secretary General under Article 4 of ICCPR for having invoked an emergency regulation in your country, reporting periodically on the measures you have taken to ensure protections of rights, even as you ensure security because of the pandemic. So they have avoided the legislation which requires that. And therefore, when people come to court, so the court becomes the only instrument available for trying to come up with a balanced decision that tries to balance security versus rights. So to what extent our judges have played this role in the various cases that may have come before them? Because I think it's very important to do an examination and determine the robustness or otherwise of the judges. Have the judges been also, have there been cases where judges have decided politically that we are now in this pandemic and therefore we cannot even entertain you, even if you are saying the security forces have beaten me, they have burnt my house and so on and so forth. We know that in some countries like South Africa and Kenya, people have been shot dead in their houses and by overzealous security officials in the name of COVID-19. And then at the same time, civil institutions have been closed, like Parliament, to oversee the administration of the regulations introduced. So the only role, therefore, for protection is the judiciary. And I think that is very important. And then finally, the issue of socioeconomic rights, the lady that has presented on that. I was also hoping that I would hear something on the right to education, the impact of coronavirus on the right to education. As you know, globally, the first victim of COVID-19 was education, the closures of schools. So what can we say about this? Because of lack of uniformity of rules on what should be done. At the moment in South Africa, they are discussing, they don't know whether the students should return, the pupils must return to school. And last week they started returning, the senior classes started returning. At the same time, there has been an escalation of COVID, and that is a problem. So there has been a fundamental effect on education. And we will not know exactly now how this is affecting society in general. Perhaps in the next 20, 30, 50 years is when we shall actually take a proper count of the effect of coronavirus and COVID-19 on education. And I thought that education should have been underlined. And then finally, employment. I think employment, she has rightly mentioned it. However, just to underline that the majority of poor people, usually in the informal sector employment, were so badly affected with the hard lockdowns in countries like where I am in South Africa. And they just lost employment because the majority of small businesses cannot stand workers not coming for work, even for one day, and still pay them, let alone 1 week, 1 month. So once workers do not come, then they dismiss them instantly. In fact, you are told that you stand dismissed. We don't have to take any action from our side, and yet the company was closed because of an act of God. Now, what has been the response overall policy-wise from governments in respect of the poor workers, the lowest on the rung of the ladder? This is a problem. Of course, some companies may have got some stimulus packages to try and cushion the worst effect of COVID-19. But in the majority of our countries, these are not available, or if they are available, only to the few companies. And then they put money into the pockets of the company owners and not into the pockets of poor workers. And that is a problem. So even if there is a social fund established, it's usually too small to cater even for a month for a family of 5, 7 people. 250 South African rand you give to a family of 5 to look after their needs, basic needs for 2-3 months of the closure of the company or the activity they are involved in on a self-help basis. So these are some of the problems, and I want to conclude to say thank you very much for the opportunity. I enjoyed listening to your various contributions. Thank you.
So Fiona, please. I mean, Sarah, please.
I can answer on the socioeconomic.
Yeah.
So what I said was that what we have seen with COVID-19 is sort of reinforcing of previous economic challenges. The disconnect between our economic growth objectives and our social welfare needs. Social welfare, I mean health, education, water and sanitation, food, social protection. Without coherent social policies, I think, as you've rightly mentioned, Professor, the exception has been maybe South Africa, which has really tried and maybe come out of, has tried to sort of implement not just the public health measures, the lowest common denominator of keeping people alive, but also supporting them in the process as they lose their access to what were already very precarious livelihoods. Very, very precarious livelihoods, living on a day-to-day basis. Of course, what lockdown has meant is the closure of schools and the closure of those facilities. And what we see is the reinforcement between sort of rural access and urban setting access to education, because the proposals to address sort of the educational needs have centered largely around the use of online education and to some extent local community radio and so on. And of course, we've already talked about the disparities amongst those who have access to these tools. And so I think, it's difficult to talk about the legal aspects without taking a holistic look at the way in which we grow our economies, we plan our social welfare, and we are now in a situation where we are trying to respond to this crisis without the adequate infrastructure, without the adequate data, and without the adequate investment in terms of resources and people. We have been, under the sort of, for the last 30 or 40 years, engaged in a process of what we call the sort of neoliberal aspect to economic management, which totally took away the responsibility of the state to provide for these basic social welfare needs. And the idea was that these expenditures, these social welfare expenditures, were actually too expensive for us as a continent to afford. So we were sort of informed that this is too expensive, we can't afford it. But what we see with COVID-19 is actually we can't afford not to have them, these basic provisions. And so the question of social welfare, whether it's related to education, whether it's related to employment, water and sanitation, we've seen these this ridiculous situation in which when we took a public health approach, we provided
12 hours.
clean drums of water for people to wash their hands in contexts where they didn't have water, clean water to drink. You know, so if we don't take a holistic look at you know, the challenges, the economic and social challenges that befall us, and if we don't, I mean, most of us are operating under a regime of public health laws that were developed in colonial times, which had different objectives. So Public Health Act in Uganda was 1934, in Zimbabwe 1922 or something, until it was recently you know, revised. But most of us are sitting on a plethora of, or sitting on a framework that really does not fit the needs of the vast majority of us as citizens. And therefore it makes the question of administering and access to law a fundamental question. What laws are we accessing? What laws are we implementing? What laws is the legal profession using? What you know, are they using to determine what's important and what isn't, and so on and so forth. So I think it requires more than, there is a place for legal arguments, there is a place for thinking about the place of the legal practitioners, but I want to suggest that what we are facing is a much larger problem that needs the efforts of a much broader, I suppose, network of people to think about what is really needed in terms of our sort of economic objectives, our social, and our social objectives, in order to make the process of administering law more accessible and just.
Okay.
Over.
Thank you very much, Sarah. I'm told that our time is now coming to an end. I'm going to request that Justice Mwale and Justice Dingake respond to Professor Michelle in brief. How many judges have been affected and infected by COVID-19? What measures are being taken to test and protect judges and lawyers and prosecutors? And lawyers, you can add prosecutors, you can add prison staff, because in Uganda here we have had a prison that was said to have been infected. It was then we also had an entire police barracks that was also said to have been infected or something like that. So let's talk about these justice actors, not just the judiciary. Is there any effort, what efforts are being made, you know, to protect them?
Thank you, Martin. Thank you, Professor Hasingula. It's good to see you. And thanks for that comment. There are many questions that were raised. I don't think, given the time now that is left, we have enough time to deal in detail with all of those questions. Speaking for myself, I had already planned that after 11, Martin, you release me and I'll go and attend to other matters. But let me just say overall that I'm not aware of any studies actually how judges or lawyers have been affected or infected. I think it's a very important concern that we need some studies around that. And you know, Professor Zingula, on a light note, I realized you said that COVID was an act of God. I still await full evidence on that aspect, whether it's an act of God. But judges across, in Botswana, we have had judges dealing with COVID-related cases in Malawi, in South Africa, and they have acquitted themselves differently. And a deeper interrogation as to whether they got the balance right, I think is for another day. But one can simply say that the role of judges, whether there is COVID or there is no COVID, is to ensure that the rights of the people are protected and the Bill of Rights in particular are enforced, and that any limitations that are there can only be upheld if they are reasonably justifiable in a democratic society or they are necessary. I think that is very important. There was an earlier question about video link. I'm not sure whether in Papua New Guinea there is any video link in terms of which maybe prisoners can move their bail applications and so forth. But what I could highlight is what Fiona said about what COVID has really done. It means that the legal practitioners actually must be very exhaustive and clear in the affidavits, because that is the only evidence that is before the court. And if they are not clear in terms of the affidavits comprehensive, and that may have some prejudicial effect on the overall result of any application that is moved. Thank you, Martin. We don't have much time.
We don't have time indeed. Justice Mwale, do you have a comment in response? Justice Mwale?
I forgot to unmute.
Okay.
I forgot to unmute. Yes, I would just say Justice Dingake has covered everything. I would just comment on the fact that it's a pity that no studies are being done about judicial officers and justice actors. We need more research organizations working on this, because access to justice depends on the well-being of the officers that are in charge of it, that are entrusted with it. Now, if these officers are going to be worried and, you know, about their health not being adequately protected, it does have an impact. So I think this is an important angle that we've so far not been looking at, and perhaps somebody can give it the attention it deserves.
Okay, the Africa Judges and Jurists Forum will consider doing a study on the impact of COVID-19 on the justice sector, on the justice sector actors. So I see here 2 or 3 questions from one person. Console Ndaikunda. My name is Console Ndaikunda, lawyer member of International Bridges to Justice. I have 2 questions. The suspension of cases is a big issue for the accused persons, and I would like to ask you how to manage this difficult situation as lawyers for human rights defenders. 2, how can we deal with the impact of COVID-19 on regional integration process in Africa? 3, several. I have also a comment about how we can try to prevent abuse and protecting the rights of the accused in prison, accused person in this period of COVID. As lawyers of other jurists, there are too many questions. She has too many questions. I think let's just answer those. Hello? Hello? Can I be heard? Judge, do you have a response? Justice Dingake, do you have a response to the questions of...
I didn't quite get the question. I have no response.
She has very many questions. She or he has very many questions. Okay, is there any comments from anybody?
Unfortunately, I haven't seen the questions either, so it's difficult to respond.
Okay. So, is Arnold there? Mamu,
I
is
saw
Arnold?
left.
Okay. So I would like to thank you very much for having accepted to participate in this meeting, either as panelists or as participants. Clearly, the things we have taken out of this meeting, and you will be learning of them in the days to come. At least the last one we have picked up is this study on the impact of COVID on the justice sector. We're definitely going to take that up. The digitization of the judiciary, we are going to take that up, and we will get you informed in the future when we take it up and how it proceeds. Fortunately, we're also speaking with in the presence of Sarah, who is I was told this morning that Sarah is a funder, so she might be funding some of these things. No, that's a joke, Sarah, don't worry too much. So thank you very thank you very much, Justice Mwale. Thank you, Professor Nsungule, Justice Dingake, and Mr. Franck Kamunga. Merci beaucoup. Till we meet again.
Merci beaucoup, merci.
Thank you.
Thank you so much. Okay,
Thank you.
bye.
Thank
Bye.
you. Bye. Bye.
Bye.